And you're alive.
Thank you. Good morning. It's May 9th, Friday. You are in Senate Judiciary, and we are going to be taking testimony on House Bill 222, an act relating to civil orders of protection. And we have Anhala here from the Office of Racial Equity. So I guess we'll turn it over to you. Just introduce yourself, if you would, please.
Insurance.
Sure.
And we also have Anthony, just from our office as well.
Oh, yeah.
Okay. Buenos dias. Thank you for having us. Today I'll be talking about H222. My name is Angela. I'll be talking, or Anthony is also presenting this testimony with us. And I would like to start by saying that this conversation is very important to us as an artist, but to me as a person, because I am a domestic violence survivor, also an immigrant woman, bisexual Latina, and Colombian, as you might have noticed from my accent. Anthony, this is a conversation very important for him as well. You can go ahead.
So this is this is important to me as I work full-time as a Office of Racial Equity, DRJS, Division of Racial Justice Statistics Analyst. But I am also a former victim specialist for the city of Burlington and currently work part-time in the Caledonia County State's Attorney's Office as a victim advocate.
So from there, we know that this bill gives courts a new tool against domestic violence, and this bill would let judges or their people relieved from abuse orders to complete domestic violence accountability programs, which is like, educational programs. Those are the key changes. Now, court, as you might know, but just for the sake of your viewers, court can order debuff attendance. For now, no criminal penalty for skipping those programs is considered. And this bill also includes motor stacking definitions and gender neutral language. But there is a debate in here. There are arguments supporting this bill and against this bill. So we would like to, put that on the table. Some people believe that domestic violence isn't taken seriously enough, which is true. And some people don't care and they abuse of their power a lot. So maybe this bill can increase engagement in these educational programs. Anthony has talked to Mary, which is the PD Burlington PD domestic violence advocate, and she has some thoughts about this one. Would you like to share those supporting the bill?
So one of the things that, in speaking with Mary McAllister, she's the domestic violence advocate out of the Burlington Police Department. She states that she thinks that she supports the bill in that she thinks that multiple plaintiffs who have filed RFAs in the last 6 months have lost access to their vehicles, even though they were the ones paying for it, and that they were dependent upon it for getting to work and getting their kids places. So she thinks it's awesome that in the bill that it would allow individuals to retain vehicles in those. One of the issues she did have, though, was with many folks that I've spoken to about the bill is just the enforcement portion of the say process, whether it's the violation of the MFA or mandating individuals to go to the DVAP training. How would that enforcement work? So
yeah. And also the Domestic Violence Fatality Review Commission has highlighted that accountability programs are important. So those are like the main arguments, but as always, there are arguments against the bill. And number one, it is not pedagogical to obligate people to attend those trainings. Like, just think of the times where you really wanted to learn something, or you because were you learning it because you wanted to, or because somebody, I don't know, your mom, your dad, your whatever told you to do so? So at the end of the day, we do believe that it's not effective to make this kind of stuff, which is super important, to make it mandatory. Education should be voluntary. And at the end of the day, it's very hard to learn and unlearn stuff, especially stuff that is related to patriarchy or macho culture. Like if we are making those things mandatory, we do not believe will help and this will be effective. So that's like one of the main arguments against the bill. There are also complex implementation issues that exist if this passes as it is right now. So people with multiple court cases can face contradictory requirements, like staying away from someone while having home confinement. Would you like to elaborate more, Anthony, on the issues?
So some of those issues, as raised, again, talking with prosecutors, talking with judges, and just experience from working with victims, those folks that have RFAs may have contradictory conditions if they also have a family court case with parentage, or if they have conditions because there's a concurrent court case and they get conditions from probation. They may have conditions that state one thing and they go against the RFA. So they may, have 24-hour curfew. Well, you can't have a 24-hour curfew and also from an RFA be told that you have to go to programming. Those things could be at odds with each other. Or there are folks who live in the same home, because an RFA doesn't mean that two individuals aren't in the same house still. The conditions could be that they just don't harm that individual. Well, if that person's supposed to go to training, it's reliant on that the survivor, victim, to report that. Well, is it really in your best interest, if you're living with the person who's harmed you, to also file a motion that they're not doing what they're supposed to be doing with the court? So there's certain things there that happen that it makes it complex, because DV itself is complex. When it goes to court, not all folks who get RFAs also have a criminal court case. Those two things can be separate.
At the end of the day, we do believe that we should have, this is an open question, an open conversation. Like, why are people not going in the first place to give up program? Like, is it because they don't want to, or is it because of structural factors like work schedule conflicts, transportation issues, lack of childcare, stigma, denial? Like, we don't know. So those things should be, I don't know. I think it's interesting to know what is happening before moving with the bill, like what evidence we have, and I do, by any means, I have the answers. That's why I'm saying this is another question and conversation. So to recap the Office of Racial Equity's position, we do oppose that CUR can order give up domestic violence attendance program attendance, and if we create a criminal penalty for skipping those trainings, we do believe that this is not the path to move forward. Adding more crimes to the list is not something good. And we do believe, we know that it's a civil contempt proceeding right now. But I just wanted to say that out loud. And we also talked to ACLU Vermont, and they are not interested. They believe this is not the path as well. But we do support the modern staffing definition that the bill has, and we appreciate the gender neutral language that it contains, and those modifications are important.
Yes. Do you have a question?
I did have a question, because I wanted to make sure that you were aware that there has been some conversation about actually moving away from the civil contempt charge to an actual criminal charge, and I wanted to see if you had thoughts on that.
Yeah, and like talking for the Office of Racial Equity, we do not support it. We do not believe this is something that is going to work, and it's not good for the way the criminal justice system works. Anthony, do you have thoughts?
Yes. So moving away from it, turning it into a criminal charge, creates more of a caseload for state advocates that are already overburdened with cases. So what you then do is have somebody who can back up multiple cases. We've already proved, it's shown within courts now that when people violate those, there aren't strong enough sanctions for that individual when they do it now. That will only burden state's attorney's offices with going to now roll even more cases, which then you might end up seeing more plea deals that are more favorable to defendants and away from the support of plaintiffs. So I think that's one of those other areas that really make it tricky. And also, what you're doing is you're telling an individual as part of the continuum that you're making that they're going to have these set of rules not to harm a person and do a training that they may not be able to do. So now that gives them something to contest in court. And you're asking me to go to this training. Well, I live out in a rural area. I don't have transportation, or the times that I have to do it, I have to work, especially if that individual relies on work in order to pay to live.
Excuse me.
Yes, sir.
We have a question here, Senator Bruce.
So, sorry, Anthony, I am just hoping to clarify. So it sounds like the office's position is that you would also oppose the civil contempt piece?
Yes.
Yeah, so basically we should just pull that, I think it's section J. Pull that whole section that allows the judge to order.
The training to be mandatory.
Okay,
And if there are some conversations to make this criminal one, we would also post that.
right.
And
So,
it's not only us, like it's really everyone as well.
but it's fair to say that your preferred position would just be to remove
Mm-hmm.
that section.
Mm-hmm.
Yeah, okay.
Yeah, because there are good things on it. That's why we made those clear and included the slide.
And if I might follow up on that, that's interesting. Just due to the fact this was something that the Domestic Violence Commission wanted, along with Dr. Atom suggested that for actions there had to be consequences for actions, and they actually supported the criminal aspect of this. So I'm getting mixed messages here.
So I
Yeah.
think
Yeah, go ahead.
I think that what we find in the judicial system, and I think many folks, whether from law enforcement all the way to the courts, prosecutors, there's a difference between what the law says and how it's enacted. In doing this, it sounds like, and it sounds like on paper it would be really good for for the survivor, but it creates more problems than it actually solves. I think strengthening the support um, the criminal side for a lot of those folks does more than the RFA. Because again, just keep in mind that the RFA process is a process. An individual has to apply for a TRO, then they have to wait for the RFA hearing, then be granted the RFA. That can happen without a person ever being charged for a crime. So this entire process, if they have the RFA for a year, that happens separately by themselves, and they may not have that support if there isn't a criminal case also happening. So what you're saying is if this person violates that, the victim is the one, or the survivor is the individual who is the one that was be mandated to file that motion in the court that this individual is doing this thing. There would be no other mechanism besides them doing it, which creates an undue burden to the plaintiff at that point.
And I would also add that there, I agree with what you are saying. There has to be consequences, but maybe we do need to have maybe other things in mind when we are talking about consequences. Making a class or a course mandatory is maybe not the best way to move forward. That's why our office is, presenting this question today. What are the structural roots of this problem? Domestic violence against women and children, what are the structural roots of this problem? And, what are those systemic inequalities, empowering balances, particularly regarding gender, that we see here in Vermont? So if we address those, maybe if we think something different, I think we can really do something more effective at the end of the day instead of just making the class mandatory. Here are just some thoughts. Like, we do know that harmful cultural norms that include traditional beliefs such as a man has the right to power over a woman, or this idea of male superiority, or this idea that domestic violence, it's your own problem, it's your business because it happened at your home or house. This is like, those ideas are very problematic. And if we do something to address those, maybe we can see the consequences that Dr. Ethan, thinking more from a systemic perspective, will have. We do know that domestic violence is rooted in women's unequal status in society. So what are we going to do to change that? And there is like an unbalanced distribution of social, political, and economic power between women and men. So those are like some roots. And maybe if we do something there, we can see that we can like maybe stop this from happening. And here are some other ideas that the office has. So number one, prevention should be a central focus to address structural causes. We do believe that integrating education to transform cultural patterns is important, and bringing awareness to the topic helps a lot. We do have the Agency of Health and Human Services, the Director on Trauma Prevention and Resilience. Her name is Kaya Ganguly, and we should be having conversations with other agencies, and it would be great if you can invite her to testify because she knows a lot about trauma-informed responses. And I know those will be, she has like very valuable insights. Encourage collaboration among agencies to reduce fatalities. Those are good ideas as well. Addressing systemic inequality and exclusion is crucial. And listening to more people, like listening to organizers, advocates, feminist groups in the state, like community members. They do know a lot. So that's an idea as well. And finally, I'm Colombian. So when I moved to this country, I found that a lot of the times when people are talking about policy here in the States, we only see to what other states around us are doing, such as Massachusetts or Connecticut. But what if we see abroad? Like Latin American and the Caribbean countries, they have very good policies to stop this from happening. And they center those policies in prevention, attention, sanction, and reparation. Like those are really good policies that I would like to, it would be cool if we can also learn from what other people have been doing, because this is not only a problem that happens here in Vermont, it's a problem that happens in other countries. And in Europe, for example, Ireland has a very good public policy that has four pillars: prevention, protection, prosecution, and policy coordination. So maybe we don't have to reinvent the wheel. We can just learn from other countries and what they have done.
Did you have a question?
And finally, what if we start by considering the relationship between firearms and domestic violence in Vermont? Like maybe that's a place where we can see the consequences that Dr. Ethan was saying. I don't think we are saying the RDAP and us as an office are saying like contradictory stuff. Maybe the focus where to have those consequences, where we can do stuff to, effective, to be more effective. So yeah, I would like to highlight that because according to the Domestic Violence Fatality Review Commission, in their last report, 2025, Vermont recognizes that firearm injury is a leading cause of domestic violence, homicide. So yeah, firearms are heavily implicated in those kind of situations. And if you have a gun in a place where domestic violence is happening, that could be like super dangerous. Anthony, do you have thoughts on the last?
So I will say that one of the portions of the RFA is the relinquishment of our firearms, and that happens at the TRO. So you don't have to wait until you go to a hearing for an RFA. When an individual applies for TRO, the firearms can be removed from the home. I think having a system in which at that time that the TRO is granted if it's known that there are firearms in the household, that they're removed at that time. So not waiting or having the survivor or the responsible party get with law enforcement to figure out how to do that at the time. If it's noted that there are firearms in the home, being able to take those and secure those through the process would be helpful. I would say personally, in the work that I've done with DV survivors, it's a process in which a TRO is granted, and then we have to work with trying to do that. And an individual that's going through domestic violence, they have trauma brain. There's a lot of things that they're trying to do. They're worried about safety. They're worried about security. They're not able to process trying to gather up firearms or how many there are in the home. They just want to be safe. I think we can put the onus on law enforcement in that moment. And even before that, the prevention. When you go to a call, are you looking at signs? Having officers trained in a way that when they respond to a home for an incident that may be an assault or something of that nature, being able to really speak to an individual to gauge whether domestic violence is happening and being able to do, lethality assessments and making recommendations at those points, not waiting and leaving and then coming back days later when, that person is in danger. So I think there's steps, we have them in Vermont that happen, but to make it so that it happens all the time would be helpful for both survivors and I think it's just helpful all around.
Okay, thank you, Anthony. Anything else? I do have a question. So in listening to your testimony, you don't support either the criminal and or civil penalties for Section J, but such as Senator Ruth asked, if we simply eliminated Section J, that would kind of take care of the civil and or criminal penalties involved with this. Do you have any recommendations as to any programs that they should voluntarily attend, or as you
Yeah, the
stated?
program is already voluntary and it's free, which is good
Yeah.
because it's it's investing money on it. Before you had to pay, now it's free. My recommendation would be to listen to more people, like to bring more people at the table. We need to amplify other voices. Like the office is not the only one who, cares about this kind of stuff. There are a lot of groups that maybe we should be listening to their ideas, and their thoughts. So that would be my recommendation to
Yeah,
make
and-
it more diverse.
And in response to Anthony's, we have separate conditions of release, and if you have this program here, which is supposed to be at home, that's not unusual for courts to order individuals who are presently housed at their own residence in their 24-hour curfew to allow them to go to doctor's offices, appointments, such as this program here. But evidently, this program may be a moot issue depending on what the committee decides down the road here. So a moot issue, I should say.
Say there are also points in which an individual gets an RFA and the individual who is the survivor gets to stay in the home, and the individual who caused the harm is not allowed to stay at home. So now that renders that person effectively houseless. So if that person is now trying to find housing, how do we then get them to do programming if they don't have a stable place to even be? So again, there's the way that the system works here in Vermont. In changing one thing to support one individual, you then create another unintended issue for the other party in both directions. I think it takes working with victim advocates at the state level, at the municipal level, and at some of the nonprofits, and working with prosecutors, working with judges. How does the system currently work from beginning to end? Where are those gaps, and what does it look like to fix those gaps so that the person that is being harmed feels safe and secure? Because often what they want is just for this not to continue happening. And what does it look like on the other end to get that individual the support that they need, whether it's trauma support or whatever, so that they aren't committing that harm to that individual? I think it's two-sided, looking at supports for both sides. I don't know if this bill does that I think that's where our stance is that we like the bill in theory, but it doesn't address problems. It creates more problems.
Okay, thank you.
Maybe we need more systemic thinking to address those issues, because those are so complicated. So that's where.
We have found it's never easy, so. We have found that it's never easy, so do you have anything else you'd like to present to the committee here?
Yeah, no, that's it. Thanks for having us.
Any questions? for the committee?
Helpful.
Thanks very much. Thank you very much. Thank you, Anthony.
Yay.
So, yes. Gonna wrap up our day. So